Good afternoon. Welcome to the Analyst. Today we'll be discussing 5 newspaper articles today from the Hindu and the Indian Express. The first topic that we'll be discussing today is related to Parliamentary Conduct. The second topic is related to the water disputes, the Cauvery row, and we'll be discussing the resolution of water disputes as well. The third topic is related to the tussle between the chief ministers and the governors. We'll be taking up a few cases. The fourth article is regarding the South-South learning and collaboration, what India and Africa can learn together. And the final article is regarding the Election Commission of India. We'll be discussing Article 324 and the judicial interpretations of the Article 324. The handout for this discussion will be available in the description of this video for your kind perusal. Coming to the first article, that is the Parliamentary Conduct. This is important in GS2, the Parliament and the state legislatures, their functioning, structure and conduct of business as well as privileges. Now, the context behind it is that there have been frequent disruptions in the functioning of the Parliament which affects the efficiency of the Parliament. Now, Parliament is the temple of democracy. It is the legislative organ of the Union government. But if we observe in the past few decades, there have been certain issues which have plagued the Parliament of India. If we look at the number of working hours, that is the productive time that is being used, that has been steadily declining. From the graph we observe that since 1952 till 2018, the effective time, the efficient time, the working time, the sitting time of the Parliament has almost halved. And this has affected the efficiency of the legislature and which affects the core functioning, that is the law-making function of the Parliament. Since 2014, Rajya Sabha has been unable to function for 40% of its allotted time, and there have been frequent disruptions. There has been an attitude of disrupt and devour attention, and it affects the efficiency again. Even the question hour, which is a very important aspect of legislature, that is also not being utilized properly, and it is due to frequent disruptions again. If we look at the bills, when a bill is passed in a parliament, it has to be subject to immense scrutiny, it has to be subject to the debates, it has to be passed only after thorough debates. But there has been insufficient scrutiny. For example, if we observe in the 14th Lok Sabha, 60% of the bills were vetted by the department-related standing committees. The same number was 71% in the 15th Lok Sabha. Whereas in the 16th Lok Sabha, only 27% of the bills which were passed were vetted by the department-related standing committees. This leads to passing of bills through voice vote without adequate scrutiny. And there is less space to individual members. One, it is due to less time for which the Parliament is able to function. And secondly, the individual members, they are not accorded due importance. Their voice is not adequately heard. For example, Shri Shashi Tharoor had tried to introduce the transgender protection bill, but that was also allowed to lapse. This was a reasonable bill actually. Then in terms of the research infrastructure, the staff of the library and reference research information system, that is not up to the mark, and the budget that is allocated for the research, for the parliamentary research, that is less than 0.05% of the total budget of India. Whereas if we compare it to the world average, there it is about almost 0.5% of the total budget that is allocated usually to the parliamentary research. Then the Parliamentary Standing Committee reports, they are not deliberated properly. Usually they are rejected without stating any reason because they are not binding, they are just advisory in opinion and hence they are not accorded due importance, whereas they are producing reports after immense research and thorough work. There is an absenteeism on the part of the MPs also, the members of the Parliament, they are not attending the Parliament, and there is a weak opposition. Weak both in terms of number as well as unity, and it affects the functioning of legislature because the opposition, if it is not strong, it is not able to effectively question the working of the government. Then in terms of women representation, if we observe, as per the Inter-Parliamentary Union, we are ranked at 153rd place out of 190 nations. we are having women representation of only 15% in the lower house, whereas Rwanda tops the list with about 61% representation. If you look at the Scandinavian countries, the representation of women in the lower house is about 40%. Even in Pakistan, it is almost 20%. That is, women are about 20% in the total lower house list. Then there is a partition behavior of speaker also. For example, in terms of the disqualification decisions, the decisions which are taken under Article 102 or 191 in case of state legislatures, they are partitioned. In terms of labeling a bill as a money bill as per Article 110, there also the speaker's behavior is often accused of being partisan. For example, the Aadhaar bill, the Aadhaar Act, which was subsequently enacted, it was alleged that it is not a money bill because it contains provisions other than getting money out of the Consolidated Fund of India, which was under the Section 7 of the Aadhaar Act. Therefore, these are affecting the functioning of the parliament. Then in terms of the privileges, there are certain issues there also. First thing, the privileges of the MPs, they are not codified. And in the absence of codification, the legislators themselves, they are the sole judges of determining what constitutes their discretionary powers, their privileges. Then they are often misused also. For example, in the case of Karnataka, the Karnataka Legislative Assembly passed a resolution for the arrest of 2 journalists on the recommendations of its privileges committee, which was an outright misuse of the privilege. Due to the disruptions in the parliament, the executive often resorts to promulgation of the ordinances, and the criminalization of politics that has led to almost 43% of the MPs facing criminal charges in the 17th Lok Sabha. When we look at the anti-defection law, there has been horse trading which still happens, and it is a betraying of the public mandate. It is an injustice to the constituencies, and overall there is an absence of the code of ethics and its implementation to ensure there is proper parliamentary conduct. Now, what are the suggestions to improve this situation? One, there can be public participation and feedback in the pre-legislative process. This public feedback, putting the bills in the public domain, will invite criticism before the bills are enacted into the acts. Political consensus should also be tried to be built between the various political parties, and we can revisit the anti-defection law also, so that the whips, they can be limited to where the bill affects the very stability of the government. Otherwise, the MPs, they should be allowed to vote as per their conscience. They should be free to vote irrespective of the party lines, depending upon what they believe in. Then an annual calendar can be announced in advance. For example, even the National Commission to Review the Working of the Constitution recommended that there should be fixed number of sittings per year for the Lok Sabha as well as the Rajya Sabha. It recommended 120 sittings for the Lok Sabha and 100 for the Rajya Sabha. Plus, research fund should be there, and the funding should be adequate to ensure that parliamentary research, it is not affected. Other suggestions include, we can borrow some suggestions from UK. In UK, for 20 days a year, agenda is set by the opposition. Even in UK, there is a Prime Minister's question time, usually once a week, usually every Wednesday, roughly 30 minutes, MPs ask questions to the PM and the PM answers, and it is widely watched in UK. Then in Canada, about 22 days a year, the opposition initiates the debates. Therefore, the opposition is accorded its due space in the parliament and lawmaking. The 14th All India Whips Conference even recommended that one day every week can be reserved for the discussion on the concerns of the members of the parliament. Then we can also explore the codification of the privileges. These measures will ensure that the parliamentary conduct is up to the mark and there is smooth and efficient functioning of the parliament. The second article is regarding the water disputes. And this is important in GS2 as various tribunals are set up to adjudicate the water disputes, as well as in GS1 and 3 for the topic water. Now the context behind it is that a delegation of MPs from Tamil Nadu will meet the Jal Shakti Minister to submit a representation urging the Cauvery Water Management Authority to release 12,500 cusics of water to Tamil Nadu. Now, before going on to particularly the water disputes in general, let us first talk about the river Cauvery and the Cauvery dispute in particular. Then we'll be coming on to the water disputes, the challenges, the governance challenges as well as the solutions. Now, the river Cauvery originates in Brahmagiri Hills in the Western Ghats in the state of Karnataka. Its origin is at Talakaveri, which is even considered as a pious place. It is often referred to the Dakshin Ganga in the south. Its tributaries include, this is important from the perspective of prelims, include Harangi, Hemavati. Hemavati joins Cauvery near Krishnaraj Sagar. Lakshman Tirath, Kabini. Kabini originates in Kerala and flows eastward before joining Cauvery. And Shimsha, Arkavati, Swarnavati, Bhavani, Lokpavani, Noyal and Amravati. These tributaries you should remember for prelims. Now, what is the dispute background regarding the Cauvery water? The dispute was originally between the Presidency of Madras and the princely state of Mysore ever since 1892 during the times of British also. Then in 1924, the Mysore and Madras entered into an agreement for water sharing which was to be there for 50 years. Now, after its expiry in 1974, subsequently, the state of Karnataka started diverting water to 4 of its newly made reservoirs without the consent of Tamil Nadu. Now, this affected the water situation in Tamil Nadu and it started experiencing shortages, and therefore this dispute led to the formation of the Cauvery Water Disputes Tribunal. Now, the tribunals are established under Section 4 of the Interstate Water Disputes Act 1956. Post the formation of this tribunal, it awarded the final award in 2007, 17 years after its formation. It specified the exact amount of water which was to be shared between Karnataka and Tamil Nadu during various times of the year, during different months of the year. It allocated the water to the 3 states, that is Kerala, Tamil Nadu as well as Karnataka and the Union Territory of Puducherry, and it reserved a small portion for the environmental purposes also. It mandated the constitution of a monitoring authority as well to regulate the release of water, which was mandated by the tribunal. But it did not give any detailed formula when there is water scarcity, that is when there is insufficient rainfall. There it merely stated that it will be proportionately reduced, the water allocation will be proportionately reduced to all the states. In 2013, the government notified the order, but later on Tamil Nadu approached the Supreme Court. Under Article 136, it filed a special leave petition because the government of Karnataka was not following the order of the tribunal and it was not releasing water as mandated by the tribunal into Tamil Nadu. Therefore, in 2018, the Supreme Court came up with the judgment. There it declared Cauvery a national asset. And it largely upheld the water sharing arrangement which was put into place by the Cauvery Water Disputes Tribunal, and it even notified the government to ensure there is a Cauvery management scheme, and the constitution of Cauvery Water Management Authority was done. Now, Tamil Nadu government, due to the continuing water crisis, has approached again to the Jal Shakti Minister to ensure that more water is released from Karnataka. Now let us go back into the background of the water disputes and how they are resolved in India. Water disputes, they are resolved as per the Article 262 of the Constitution. Article 262 bars the jurisdiction of the courts. Even the Supreme Court is barred from interfering into the adjudication of the water disputes between the states. As per Article 262, the Interstate Water Disputes Act 1956 was enacted, and correspondingly the adjudication is done by the tribunals. Now these tribunals, they are not permanent tribunals, they are temporary tribunals as per the Act of 1956. After the tribunal makes an award, the tribunal is dissolved. The award of the tribunal carries the force of the decree of the Supreme Court, and it is binding on the states. But there are certain challenges in the implementation of this award as well as the adjudication of water disputes through this mechanism. What are the challenges? First, there are adversarial litigations. How, for example, once the tribunal makes a final award, the states still approach the Supreme Court through the special leave petition under Article 136, and it leads to a chronic delays in the final settlement of the dispute. Secondly, there are no avenues to redress the grievances if the states have any after the tribunal has been dissolved, because the tribunals, they are not permanent. It even leads to constitutional crisis at times because it pitches the legislature against the judiciary. For example, after the Supreme Court order on the Cauvery dispute, Karnataka government even indicated its inability to implement the Supreme Court order. Then there is an institutional vacuum for implementation also. There is no proper permanent implementation mechanism. Then due to other factors like vote bank politics, again there are concerns, and during the deficit years the allocation becomes even more difficult and it becomes even more difficult to resolve the dispute. And there is an absence of transparent information gathering system and information sharing system also. Information regarding the rainfall, regarding the uses of water as per the personal drinking purposes, for home, residential purposes as well as the industrial purposes, and the data regarding the surface water and water required for irrigation purposes. Now, what are the solutions to this problem? One, it has to be multi-pronged. Only legal solutions will not help. They will have to be backed with institutional, technological and political solutions. Legally speaking, there was an amendment bill, Interstate River Water Disputes Amendment Bill 2019, which recommended a few measures. For example, there should be a dispute resolution committee. This dispute resolution committee should try to resolve the dispute between the two states within 1 year, which can be extended by another 6 months. If the dispute resolution committee is unable to resolve the dispute, then it can be referred to a tribunal. Now this tribunal is supposed to be a permanent tribunal. This permanent tribunal also has a maximum time frame to resolve the water dispute between the two states, which will be 2 years, and again it is extendable by 1 year more. So a total time frame of 4.5 years is mandated for the resolution of the water disputes between the two states as per this amendment bill. Plus, there should be an expert agency for the data collection regarding the rainwater, irrigation and surface water. And this data collection should happen at a basin level. It should be scientifically done. Then another suggestion is we can utilize the Interstate Council. Interstate Council is constituted under Article 263. There it can serve as a platform for discussion and dialogue and resolution of dispute. Then the Supreme Court also observed that the water distribution between the states, it should not be equal, rather it should be equitable. The Supreme Court referred to the Helsinki rules and the Campion rules during the adjudication of the Cauvery water dispute. There it observed that the equitable distribution should be based upon various factors. For example, the hydrology of the basin, that should be considered. The climate of the region should be considered. Past utilization, which gives a kind of a right to the previous person who has been utilizing, and the socio-economic needs of the region, they should be considered before making an award. Then the Supreme Court also observed that the state is not the owner, but state is rather a public trustee because it is a natural resource, and even Cauvery was declared as a national asset. Ultimately, we should also ensure that technological and practical solutions should be implemented. The ideas like 4R, that is reduce, reuse, recycle and recover water, reduction of uses and optimum and scientific uses of water, that will in the long term help in the resolution of disputes also. The third article is regarding the tussle between the governor and the CM. This is important in GS2 regarding the powers, functions and responsibilities of various constitutional bodies. The governor is a constitutional body under Article 153. Now, what is the context behind it? The governor of Punjab sought for some information from the Chief Minister of Punjab regarding various things. For example, the Chief Minister sent some school principals to Singapore for training. The governor sought the information regarding it because there were corruption allegations and allegations of malpractices, but he did not get a proper response. Therefore, he has warned the Chief Minister that he will have to send a report under Article 356 to the President for the imposition of the President's rule if the situation continues. Now, there have been various tussles between the governors and the chief ministers of various states. We'll be discussing a few. First, let's talk about the tussle regarding the discretionary power and the seeking of information by the governor from the CM of the state. Under Article 167 subclause B, it is the duty of the chief minister to furnish the information regarding the administrative affairs of the state or the legislative proposals if the governor calls for them. But the CM of the Punjab did not furnish the information as per the requirement. There have been other disputes in other states also. For example, regarding the assent to various bills, there was a dispute in Tamil Nadu. There in Tamil Nadu, a bill was introduced regarding the exemption from NEET for the students belonging to the state of Tamil Nadu for admission to the undergraduate medical colleges. But the governor caused an inordinate delay while reserving it for the assent of the president. In the case of Kerala, there the governor withheld the assent to the bills, including the Kerala Lokayukta Amendment Bill and the Kerala University Amendment Bill. Other disputes include, in the case of West Bengal, the Governor Dhankar has been accused of summoning the Chief Secretary of the state and the Director General of Police repeatedly, and it affects the functioning. In Maharashtra, the Governor Bhagat Singh Koshyari stalled the election of Speaker for quite some time. Now, these tussles, they have been resolved through some judgments also. For example, when it comes to the imposition of Article 356 in a state, the Supreme Court gave the landmark judgment S.R. Bommai in 1994. There it classified the instances of failure of constitutional machinery into 4 parts, that is political crisis, internal subversion, physical breakdown and the non-compliance with the constitutional directives of the Union Executive, so that there is no misuse of Article 356 while imposing the President's rule, while imposing a constitutional emergency in a state. When it comes to the assent to the bills by the governor, again there are a few Supreme Court judgments. For example, in the Nabam Rabia versus Deputy Speaker judgment, there the court observed that the governor's discretion under Article 200 is limited in deciding whether the bill should be reserved for the President's consideration or not. And the Article 163 subclause 2, it must be read in conjunction with Article 163 subclause 1. Therefore, only the matters expressly permitting the governor to act autonomously based on his discretion, only those express matters are beyond the purview of judicial challenge. But otherwise, if the governor is causing an inordinate delay while giving assent or withholding assent to a bill, it is unconstitutional, and this action or inaction, the delay in this action or inaction, this will be subject to the judicial review. The Punji Commission also recommended that there should be a time limit, a maximum time frame within which a governor is supposed to grant assent or reserve the bill for the consideration of the President. The National Commission to Review the Working of Constitution also had similar views that there should be a time limit of 4 months within which the governor should either give assent to the bill or reserve it for the consideration of the President. The Rajamannar Committee recommended that the governor should not consider himself as the agent of the centre, but rather play his role as the constitutional head of the state. So therefore, the statements of the governor of Punjab saying that he will have to consider sending a report to the President for the imposition of the constitutional emergency in the state under Article 356, they should not be made casually. Rather, the report of the governor, it should be based upon objective facts and based on the application of mind also. The next article is regarding the South-South cooperation. This is important in GS2, effects of policies and politics of developed and developing countries on India's interests. The context behind it is that the author says that a comparative analysis between the India and Africa could foster a South-South cooperation, particularly in the context of food security and climate adaptation. Now, let's talk about the suggestions given in the article first before we move on to the Global South. The article suggests that there should be a promotion of agricultural trade between the South-South countries, particularly between India and Africa. For example, In the past 3 years, India has exported 85 million tons of cereal. Now, India has recently imposed bans on export of rice and wheat to ensure food security in India. This ban will disproportionately affect the African countries. Then another suggestion is the South-South cooperation should ensure that $100 billion which is supposed to be given by the developed countries for the loss and damage suffered due to the climate change, that comes to fruition. And now even additionally $3 trillion per year will be required for tackling the poverty, hunger, the persistent hunger in the developing countries and to tackle the climate change also. The author also recommends that the focus should be upon the nutritional security in the South-South countries, the developing countries, and education of women will lead to cascading impacts. For example, in India, the higher education among women, it has increased from 12% to 25% in the past 15 years, and simultaneously the proportion of the underweight women has come down from 35% to 17% in the past 15 years. Therefore, this will lead to positive results, the education of women, and the investment in the WASH initiatives that will also lead to good outcomes in the health sector in general. Now, let's come to Global South. This term Global South loosely refers to the countries that were left out of the industrialization era. These countries, they have a conflict of ideology with the capitalist and communist countries, and it was accentuated by the Cold War. This can be considered as the opposite of the Global North. So this division between the Global North and the Global South, this is essentially defined by an economic division between the rich and the poorer countries. But this collaboration faces some challenges. This South-South collaboration between the Global South countries, these challenges have changed over a period of time. The status quo nature of the global geopolitics, that is changing because of the disruptions caused by the COVID pandemic first and then the Ukraine war. The emerging challenges include 1. Securing the supply chain. This securitization of the supply chain is important. For example, in terms of the delivery of semiconductor chips, that is just an example of the modern day technology which will have to come across the borders. The rise in energy costs and the fertilizer prices, etc. For this, supply chains, they have to be ensured. Then, to ensure there is adequate energy supply across the Global South, there is a sustainable energy transition. The collaboration is important, and the technology and finance, they have to come from the developed countries. This is a major challenge here. The socio-economic development of the developing countries, it has to be considered before pressurizing them to adhere to the climate change goals. When we talk about the climate change, the historical polluters are majorly the countries from the Global North, and the Global South, it has borne the disproportionate impact of the climate change. For example, the rising sea levels, and it inundates the coastlines, and it even inundates the entire small islands. The multilateralism is a genuine challenge. The genuine multilateralism of the institutions of global governance is required to provide an equitable voice to all the countries. And hence, not only the UNSC reforms, not only the United Nations Security Council reforms, almost all the multilateral organizations like the WTO, IMF, etc., they have to be more accommodative in their stance to ensure that the voice of the Global South, that is also included. The next article is regarding the Election Commission of India. This is important again in GS2 regarding the powers, functions and responsibilities of various constitutional bodies. The context behind it is that there are concerns about the bill for the appointment of the Chief Election Commissioner and the Election Commissioners, which has been recently proposed. Now first we'll be talking about the Article 324, because the appointments to the Election Commission of India that has been discussed earlier too. First let's delve deeper into Article 324. Article 324 subclause 1 provides for the plenary powers. Wide powers are vested in the Election Commission of India regarding the superintendence, direction and control of the elections, because elections, free and fair elections, they are part of the basic feature of the constitution, and elections are the lifeblood of democracy. Therefore, the conducting of the free and fair elections, for that wide powers are vested in the Election Commission of India regarding the preparation of electoral rolls, conduct of elections, etc. Now this 324 subclause 1 includes wide powers, but they are not untrammeled powers as observed in the case Mohinder Gill versus the Chief Election Commissioner. Here the court observed that the Election Commission has wide powers, but if they are untrammeled, it will lead to an imperium in imperio. Therefore, there have to be some checks also. Election Commission only operates in the areas left unoccupied. That is, the courts read powers into Article 324. Wherever there are no explicit rules or laws made by the Parliament, there the Election Commission can make rules, and it will be subject to the rule of law. It is supposed to act bona fide, and it should be amenable to the principles of natural justice. It cannot give any orders or directions based on unfettered discretion. The powers of commission, they are meant to supplement the laws and rules made by the Parliament. They are not there to supplant them. Therefore, it possesses only executive powers, not legislative powers. This is regarding the powers vested in the Election Commission under 324 subclause 1. Now, Article 324 subclause 2 provides for the appointment and the number of election commissioners. It says that the Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners as the President may from the time to time determine. And the appointment for this, it will be subject to the provisions of any law made by the Parliament in this behalf. But no law was made till now regarding this matter. Therefore, the Supreme Court had to step in here. First, regarding the number of election commissioners. Here, till 1989, the Election Commission of India used to be a single member body. But post this case, SS Dhanova versus Union of India, it became a multi-member body because the Supreme Court observed that such wide powers, such exclusive important powers of ensuring free and fair elections, that cannot be vested into a single individual. Therefore, it has to be a multi-member body. But the election commissioners, they are not equal to the Chief Election Commissioner. The Chief Election Commissioner is not the first among the equals. The conditions of service of the other election commissioners, they can be varied to their disadvantage also. And even their removal, the removal of the election commissioners, it depends upon the recommendation of the Chief Election Commissioner. Now, but this removal, it has to be based upon cogent considerations. As observed in the TN Session versus Union of India case, here the court observed that this removal recommendation by the Chief Election Commissioner, it cannot be based upon the whims and caprice of the Chief Election Commissioner. It has to be based upon the cogent consideration for the efficient functioning of the Election Commission of India. This was regarding the multi-member status of the Election Commission. Then in the recent judgment this year, Anup Baranwal versus Union of India, the court observed that for the appointments to the Election Commission, it cannot be vested only in the hands of the political executive. Nowhere is this the case in an efficiently functioning democracy in the world. Therefore, there should be a selection committee which should consist of the Prime Minister, the Leader of Opposition and the Chief Justice of India. Whereas the recent bill which has been introduced, it says that rather than the Chief Justice of India, it will include one more minister of the government. Therefore, the Leader of Opposition, he has effectively no vote actually. Then Article 324 empowered the Parliament to make a law for the appointment to the Election Commission. This was the intention of the Founding Fathers, but there was never any law which was enacted by the Parliament. Therefore, the Supreme Court was essentially filling in the constitutional vacuum only. Even in the Constituent Assembly, there were debates whether the appointment to the election commissioners, it should be through a parliamentary law or it should be embedded in the constitution itself. Then subsequently it was left for the Parliament to make a law that shows the intention of the Founding Fathers of the Constitution. Now, because the political executive only appoints the election commissioners, this leads to a conflict of interest for the situation till now, because the Law Minister usually prepares a pool for the potential candidates and the Prime Minister advises and the President appoints. Therefore, this judgment by the court, it was a judicial activism actually, because this provision is again subject to the parliamentary law that the court again observed that as soon as the parliament enacts a law, that judgment will cease to have force, and therefore it was not a judicial overreach. Now subsequently after that, the parliament has introduced a bill for the appointment for the election commissioners, and which has been discussed already. Thank you.